Welcome to the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. Today we are going to do a recap of ICANN 83. See, Jeff is rolling in. Let me get Jeff up here. I'll say hi to David. Hey, David, what's going on?
Weather's getting warmer, really nice. And yeah, that's about it. Oh, you know what? We're fighting these problems with Xfinity. You know, they're blocking all their domain names parked at Afternic, or a lot of them.
Is Xfinity a service provider?
They're a cable internet provider in the US owned by Comcast, and they have a safe browse system called safebrowse.io, and you try to visit a website using your cable service, and you will get blocked if it's on their block list. And for some reason, I started noticing this first with some of my FD names, and then I moved over to Afternic. Then even more names got blocked, and then I moved them away, and they're still blocked. I tried to unblock them by doing a submission through Xfinity's report portal, and they don't respond. They say, yeah, we're going to get to it within 3 days, but weeks go by and there's still no response. Names are still blocked. And it's costing us money because we're not getting sales. This is what's causing the drop in sales and the drop in revenue from parking. It's a major factor.
Yeah, I'm hearing people have to check their landers all the time. It's ridiculous. I mean, the sales are super slow. Okay, so like I said, we're here every Tuesday. This is the Domain Name Law Show. There's three of us, me, David Michaels, and Jeff Neuman. We're here every Tuesday. Jeff wasn't here last week because he was in Prague at ICANN 83. Now Jeff is back. Hey, Jeff, how's it going? How was the trip there and back?
Hey, hey, good. I got a little cold, so if I sound a little under, it sounds worse than I actually am. But no, Prague is a beautiful city. Um, and sorry for being a minute late. I clicked on the link on DNL's show, and it was a link to last week's show. So gotta update that. So it took me a second. Um, but yeah, it was a great trip. Look forward to talking about it. You want me to go straight in, or
Well, before
how
we
do you
do
want to do
that,
this?
well, Jeff, I was going to say, so I see this gentleman who was speaking last week. You weren't here. Domain X, I believe, and I see he has a request. So I'm going to approve him to come up here. Maybe it was a mistake, but we'll see if he wants to speak on. He brought a not a case, but he had picked up a name, and it really wasn't targeting a company, but it was somebody else's mark in the name and so on. Let's see if he's a Domain X. Are you there? Welcome. What's your comment today?
Yeah, all good. Nice to catch up with everyone. Yeah, I'll do the discussion later in the day, like later in the session. Let's continue. Good to see you, everyone, and be part of this.
All right. Well, thanks for joining us. I like he's up here. He comes on stage and says, "Yeah, just know you do what you do. I'll jump in when I need to." All right. No, Domain X, I appreciate you understanding the format. We normally go through a little bit of news, maybe some featured topics, and then we review three UDRP cases. Today, it seems like we're going to be able to cut through the stuff pretty fast. So then when we get done, we'll talk to Domain X. And if any of the rest of you have a legal question or, have a comment or, like I said, question about anything we touch on today, raise your hand and come on up. And then also, if you have any problems on X here, go ahead and just put a comment or DM one of us and me, David, or Jeff, and we'll bring you. Let's see who this is. Request from someone else. Ragu. I'm letting people. They know. Come on up. F it up. F up the show. We're going to start with Jeff's recap of ICANN 83. But Ragu, how are you? What's going on?
Oh, I just came into the room and I was so excited to see Domain X in the room. Is it a Rosen, Andrew Rosen?
No, it's another gentleman. I believe it's a gentleman from. He'll tell us later. Maybe he's from India. I have no idea. It's probably like no,
Oh,
Todd, not even
okay, okay.
close.
But I thought Domain X is a trademark.
No, he's got Domain X Hunt anyway, and no. Um,
Yeah, yeah. Actually, I'm from Kathmandu. land of Mount Everest.
Beautiful.
So yeah.
All right. Well,
Oh, that's
thanks. And
good. That's
so Ragu jumped up
okay.
here. He thought,
Oh,
hey, Andrew.
I
No. So,
I'm just confused. Yeah,
but
I'm just slow and confused. Yeah.
well,
All
you'll
right.
notice a
No.
lot
No
of
problem.
people have similar names
Yeah.
on a
Okay. Okay.
you
So
know.
I can call myself Coca Cola
Yeah.
on
Go
a
ahead.
Clubhouse. Okay.
Go ahead.
Okay. Okay. Thank
Yeah. Okay. So if anybody wants to look at the outline, and I'll correct the link. Thanks for checking that, Jeff. I mean, it should always be correct because and normally it is, but I'll check that link. But while we get going, so Jeff was in Prague last week, ICANN 83. Jeff, tell everyone just briefly, because not no one really goes to these meetings. Not many of the folks, domain investors do. But tell us, once again, there's 3 meetings a year ICANN has, and this one, it's all around the world. This one was in Prague. Sort of, what's the itinerary? What's a normal agenda, and what happened at this particular meetup?
Yeah, so this is the second meeting of the year. And so the second meeting is always called the Policy Forum. So the summer meeting is always the Policy Forum. So it's generally a smaller meeting and a shorter meeting than the other two. And it's supposed to focus on just policy items. So there's not like a big public forum. There's not a public board meeting. There's not a whole welcome ceremony that you'd have at the other two. So it's really trying to focus on whatever policy issues are going on. So this meeting was focused on, there was a lot of discussions of new TLD stuff, but most of those discussions were not in official sessions, but outside the rooms and different meetings and people talking about it. I got to tell you, there's a lot more consultants jumping out of the woodwork or returning. Um, had a very worked up, I got very worked up with one person who left the industry for about 6, 7 years, was involved in the last round, and then now is back to get involved in this round. And he said to me, he goes, I don't understand why it's taken so long. And I think I just kind of snapped at him, and I was like, well, where the hell have you been for the last 7 years? Right? So about 7 years ago, I was one of the only people pushing for this next round and trying to get anyone to make any progress on it. And now you have these people come in, that are going to make a bunch of money off of the new round, selling their services, and they have the nerve to like complain to me about how long it's taken. Yeah, it's taken a long time, but it would have taken another 5, 6, 7 years if you know a couple people like me and a couple others weren't pushing for that next round and trying to make progress. So anyway, most of the new TLD meetings and stuff was really outside of the um, sessions. Most of the sessions dealt with things like domain name or DNS abuse and requests by law enforcement for information about domain names and response times. And so it was mostly focused on that kind of thing. But it's always worth it to see everybody that goes. And of course, the Czech Republic, Prague is beautiful. So it was a nice meeting.
Well, Jeff, so right, it sounds like a lot more of the same. Meaning DNS abuse is generally when uh, websites are say phishing, different malware, and so on. So it's a normal topic that comes up. And then now that there's this the transfer policy change, does that come up, or is that more at the registrar registry meeting? Did you see anything about that? And then I'm going to get back to the GTLDs. But so was there talk about the transfer? I guess the transfer process, the updated transfer process.
Not too much because it's right. It's before the board now, and I think they just had the last public comment period, which ends or just ended recently. And so now it's the board's going to have to accept it and then or not accept it and then create an implementation team. So transfers wasn't a huge discussion at this one. I think the last meeting and the meeting before that, yes, but now it's pretty much on to the next step for the transfer process. And there really wasn't much discussion about the rights protection mechanism review, or the UDRP review. Although I did bring it up at one meeting in a public way to just get the ICANN GNSO, the Generic Name Supporting Organization, who does the policy, to kind of pay attention to what's going on and to um, start this review as soon as the WIPO ICA report is final.
Yeah, and as I mentioned to you, I did talk with Brian Beckham over at WIPO, who runs their, the whole division regarding, of course, I'm just mentioning it to the crowd, the whole division regarding UDRPs at WIPO. And I think he would like to join us as a guest. And there was also a, a lady who runs, was it, which service provider does she run that you ran into over there? I know Brian was there as well, but, and also Renee, who handles the same at the forum. Who was the other person that you mentioned to me?
Yeah, so her name's Lenke, and she's with the Czech Arbitration Forum. I don't know her last name. Um, but yeah, I spent a little bit of time talking with her. She's actually just about to go out on maternity leave. Um, but we did talk, and so after when she's back from maternity leave, she'd be interested in coming on the show. So I think that'd be great.
Yeah. And Igor, friend of the show, mentioned that he talked with her as well, and he was spouting some very nice words to people about Domain Name Law Show. He said Jeff, David, and Todd host this thing weekly, but what a great um, mouthpiece, spokesman. I mean, help promoting the show coming from Igor. It's a nice compliment, and he actually had done some recent representations too that he sent me of helping some domain owners out, holding on to their names. I wanted to mention, okay, so Jeff, about the GTLDs, I'm seeing it a lot now, running into it. Of course, for those I'm going to mention, so Jeff and I have a joint venture. It's between my company, American Business Capital, and his firm, JJN Solutions. We started tldstrategies.com for really to help entities, to help companies apply for a GTLD in the next round and then manage it and comply with all the ICANN um, requirements. Really, just manage and operate their registry from start to finish, turnkey. So one stop in that particular space. Okay, well, so you can consider us a consultant as well, doing a lot more than just that. But there's so many companies like you just mentioned, Jeff, that now I'm running into them all the time. So they're consultants, but then also a lot of individuals, and I say individuals, I mean companies that are planning to apply. A lot of them plan on doing things themselves with their own internal lawyers. Just so, um, well, I was going to say, give me a sales tip here because I'm speaking to a lot of companies now on our behalf that are like, we are applying, and a lot of them are considering doing a lot of the applications and stuff themselves because they feel like they have experience, they have attorneys on staff, and they're basically haven't applied before, but just feel like, hey, they're going to try to take on this task themselves. What are some reasons why you suggest that they reach out to an experienced third party or consultant to help them?
Yeah, I mean, very very little about the application involves legal anything, right? A lot of the application is on the technology, on the business model, um, on just navigating through this process, which again is not legal at all. I shouldn't say at all. There are some legal aspects to it, and of course, it helps to have a legal background for some of it. But the whole soup to nuts of applying and filing comments and how comments are considered in the process and how um, the different dispute resolutions work and what yeah, an attorney can read and read up on it, but again, it real knowledge and efficiency comes with experience. And so if they think that they can do it all with their attorneys, then, you know, a couple things. Number one is, they may be good and they may get it right. Who's to say? But more likely than not is that they're going to look at getting a TLD from a legal perspective and not from a business perspective, and not understand what they need to say in an application in order to have the freedom and flexibility to do other types of things with the TLD. So, yeah, I mean, can they respond to questions on a background check? Sure. But can they talk about business model and other things? Probably not.
Okay, before we move on past the ICANN recap, was there any talk of Web3? Anything going on about, tokenizing domain names? Any, whether it was part of the conference or outside? What did you hear?
Well, yeah, I mean, there's a little bit of the Security and Stability Advisory Committee is just now looking at some potential, like, what kind of confusion will happen, or not even the confusion. If you get a domain name but you use a blockchain resolution service, how does that interact with the DNS, and is that going to cause some stability issues? Um, Nothing to get too concerned about now, but they should have been looking at this years ago. But they're looking at it, and might have some recommendations, but I don't see it as slowing anything down.
Yeah, if you want to check out the outline, everyone listening, go to dnlshow.com/outline. You'll see the things we're going to touch on. I don't know, it's stuck. It looks like Bruce and Zert keep laughing, but it's really just the emojis are stuck. But it does drive me crazy a little bit thinking you guys are laughing at everything I'm saying. So I expect Bruce and Zerk to come up here later on just to explain themselves. Okay, there was we were going to, like I said, go through some some news a little bit. There was a post, one post from Darpan I thought was interesting, at Atom saying, yeah, the shorter the better. Basically, that if you have domain names, the characters matter. The number of characters you have in it matters. Basically, at a higher sell-through rate with shorter domain names. But people were bringing up good points that, yeah, but what are they priced at? If everything's priced equally, of course people want shorter names. But if they're not priced equally, then basically the sales number, I mean the actual price does matter. Um, David, I don't. You can comment on that. But I also wanted to ask you about a post that you made. I don't have it on the outline, but people talking about being more productive from working at home. So, first, what do you think about short names? Are they more likely to have a better sell through rate if they're priced appropriately? And then also, are they more productive working at home?
Yeah. So 4-letter CVCVs sell the best, I find. The next best would be 5-letter pronounceables. Anything beyond that has to be a word. Working from home, yeah, it's the best because like you don't get strung out from driving, stuck in traffic. Half your day at the office is just spent, going to the kitchen, talking to people. It takes a while to like settle down and actually close your door and not get interrupted for a while. So yeah, working from home is the greatest thing ever.
I always hated when companies felt like you can't be as productive. That just means you have the wrong employees, frankly. So, right, of course, we can be more productive working at home. Okay, I wanted to really get to the news, and the first news article that I covered was a Domain Gang posted about this UDRP case, and I looked at it. The reason I thought it was interesting because it reminds me of the case that my business partner is responding to right now. As I mentioned, he's handling a case, KSUITE.com. It just shows that case is in, right now in progress. But this case that I have on our outline, Afianza.com, was a UDRP, and I have on the outline UDPR, just like somebody who doesn't know what they're talking about. I'll correct that. But it was a UDRP case where this The domain owner is that David Lahode, okay, that well known in our space, domain business, owns a big portfolio. But he registered this name beforehand, before their trademark. He received offers, or it was in communication with this complainant, wanted to buy the name, but then didn't come to an agreement. So then, many years later, files a UDRP, very similar to, like I said, the case my business partner's working on, where had the domain so many years in advance, prior to the trademark owner having the trademark, and then also it was a plan B, meaning they, made an offer on the name, weren't happy with the response from the domain owner or the price, and then decided to file a UDRP. In this case, AFIANZA, which means not, not secure or to secure, I believe, to secure or to guarantee, something like that in Spanish. There was a ruling of complaint denied plus RDNH, and I think that was a single member panelist too. But I think we're seeing, I think we are seeing more and more cases like this where companies, still feel comfortable filing when they, a plan B, or when it's obvious that the owner had the name before their trademark. What do you think about this article, David?
Yeah, I think it's interesting. Looking at the decision, there's a sentence here that you should take into account whenever there's a Plan B case like this, where it says the complainant makes no attempt to show that the respondent could or should have been aware of the existence of the complainant or any of its marks at the time of registration of the disputed name 20 years before, in April 2005. And the response is, yeah, I didn't know about them until 2025. Sure, because I don't know about this, whether or not they actually made an offer previously or they made some negotiations previously. That may or may not be true, but that doesn't mean he actually knew who was trying to buy the name. Yeah, so that's one thing that I see John Bearhill usually put in. He says, like, the psychic domain squatter, he somehow psychically knew that this business is going to adopt this name 20 years in the future. So, he tries to make fun of them by doing that, and we'll see that later. But yeah, you should always address that issue in this way, I think, or some way, like say, there's no bad faith if it's registered way before. But yeah, it's interesting. There was an admission in the decision where the complainant's saying when you Google Afianza, they don't show up on page 1 at all. And that's true. There is afianza.cl, which I think is Chile, and there's a couple other ones, but the Spanish company does not show up. The complainant doesn't show up. Grupo Afianza shows up, but not the complainant. And that is an interesting thing because they adopted their mark to be a generic term in Spanish as their first word, and you cannot have a generic term plus a second generic term that's not related and expect to rank for that key word. It's just not going to work. So interesting.
Jeff, this is a case, and Jeff or David explained it. It's not one of our cases we're going to review today, but so Jeff, when a case like this, somebody, it's a plan B, meaning they couldn't negotiate a deal that they liked, and it was, clearly after their or registered before their trademark. How can we, detour complainants from filing these cases? This one was ruled an RDNH, but I guess what my question specifically is, do you think if there was an increase in the cost from 1,500 to whatever, that may detour them, or what can be done to stop companies from just, in these obvious cases that they don't have really a strong position, they're basically trying to take the name. How can we detour these types of complaints?
Yeah, I mean it's a good question because I'm not sure even increasing the price would help in the sense that I don't know how much this was being sold offered for this name Afianza, but if the name was let's say offered for sale at, I'm making this up, 50,000, whatever it was, you know a UDRP is not going to cost not anywhere nearly the amount that that name would cost. So I think the only deterrence for these people is getting a decision, a reverse domain name hijacking decision. Um, but I'm not sure much can be done. Um, you would hope that someone that gets this decision, their client is seeing this and deciding that this firm, and similar to the firms that we'll deal with in the cases we have today, um, those firms should not. People should do their research on what firms they're using, and if they're paying for UDRPs that they're losing left and right, and are getting not only losing but getting reverse domain name hijacking, that tells you that your lawyer is not doing a great job.
Yeah, Jeff, I
And I
got to.
heard that some investors will raise the price after winning a UDRP substantially, and that may be fair. But it seems like, okay, so remember we did that case with RoboFlow Systems a few weeks ago. Well, the respondent actually reached out to me, and then he posted today on LinkedIn saying that they tried to extort him for 58,000 US dollars before they even filed the UDRP. And they just said, this is our demand letter, pay us 58,000 USD or whatever it was in Indian lakhs. And it is just astonishing. And now after Yash won the case, they say, okay, we want to buy it, but here's our offer, $3,200. Maybe that name is worth between 2,500 to 15,000 on the spectrum. I didn't do a full analysis on it, but how should you treat, if you were to say, okay, come back with 15,000 or 58,000, just to throw back in their face was what they offered you. How would you see that? Would that be a new instance of bad faith? I can't see that, but how would you characterize that, Jeff?
Of a respondent who basically is raising the price because they won a UDRP and now they're
Well,
charging
it was never
more.
for sale. No, it was never for sale. But the respondent who was using the name for his actual business now has to rebrand and give up all social assets and then start from scratch. So there's a cost to that. It's not like a pure domain thing. It's like a business sale.
Oh yeah, I
So,
mean if there's logical reasons for why the price is what it is, and having to, if this company respondent's now going to have to rebrand, or even if the respondent, even if there was a UDRP and the respondent said, okay, I spent 10 grand in, or I spent 5 grand in legal expenses, I'm going to raise the price and you're going to pay me for that. I mean, I think that's, I think that it also depends on, you know, how the UDRP came out, right? Like if the UDRP was that they registered the name in well, I mean, yeah, it all depends on, like, you can't, if you register the name in good faith, then the subsequent case, no matter how, whatever you do to the complainant, if it's registered in good faith, you're not going to lose another UDRP. You're not going to give rise to another claim. Could be trademark infringement, but not a UDRP. So, I mean, look, if you're a domain investor and you want to sell a name, and you're not selling a name, and then someone files a UDRP, and you haven't gotten traction, is raising the price really going to help you sell that name? I don't know. It seems like a weird response to just raise the price after you win a UDRP.
I guess it all depends on how low you have it priced. I guess because we see in some cases the price is a cost of a UDRP, and the complainant doesn't want to buy it for $1,500 or even $3,000. They file a UDRP. The respondent either has to work it himself or hire a lawyer. So then it does. Then it would make sense to say, okay, change the price from 3,000, 5,000 up to 10 or 15. But I agree with you, Jeff, that if you're already charging 20 and now you've won a UDRP, why change now the price to 50? although you could just be upset and think, this was a great name anyway. What David brought up about RoboFlow systems, that's the case that Igor helped the domain owner. The domain owner did post on LinkedIn, and I thought it was a great post saying, here's my experience. I get this UDRP. It's not only this complaint from RoboFlow, a big company, has 40, 50 million, big compared to the respondent, and says this is a U.S. company. I'm over here in India running my little operation. I didn't know of RoboFlow in the U.S., of course, but they tell me you need to pay us 50,000 Indian bucks, like David said, 58,000 equivalent here in U.S. dollars. And the guy's like, it's not just that threat, but when you first get it, he's thinking, do they have rights to do this? I mean, could my stuff be taken away, and not just the domain name, but could my business, dissolved or obviously wrecked? So very concerned at the start. He says, damn, then I'm going to fight it. So finally, gets the courage to think, I didn't even know about him. He knows he probably has a case because the facts are that he didn't know about him, and he was trying to run a legitimate business, and he wasn't targeting anybody. So that's how I always felt when I'm registering a name. I'm not buying it because of any other company. I never had any company in mind. So sometimes a company comes to you later on and says, yeah, you knew we're CBNT, like, a UDRP that I didn't even know who it was. When you're registering in good faith, you have to, explain yourself sometimes and show it, but that's always a good sort of foundation of knowing you weren't targeting somebody. So this small company knew, I'm not targeting somebody. I'm running my own business. I've never heard of this company. He gets a hold of Igor. Fortunately, Igor has, slows things down, gets his defense all ready, answers the complaint and wins the UDRP. And now the guy posts that, geez, a little more details to it, that, they were requesting this amount of money from him. And he was really scared. And he was really just posting to say, don't let big companies come in and, scare you off your legitimate business. Basically, really, you need to get some professional help in this case, somebody who knows domain name law. And, but, anyway, it was interesting that the gentleman posted some more facts about his case and that he stood strong and he won. One thing I wanted to look at here that was on our outline. Okay, we're going to get through this so we can go to our cases and then talk to Domain X about what he's doing there in Kathmandu. Okay, and Raghu, why didn't you just wait until you heard Domain X talk, and then you'd have known it wasn't Andrew and you wouldn't have had to come up here? I'm just messing with you. I mean, I'd like to sit across from you in a coffee shop. I'd do the exact same thing. I'd say, no, this isn't right. I want an Americano. Go get okay, so there's the second annual Levine lecture coming up July 21st. I got a link on our outline at dnlshow.com/outline. It's the featured speaker this year is David Bernstein. He's a panelist. He's a lawyer too. But so it will be very interesting. You can sign up. I believe. I'm certain it's free. I say free, and I don't know if you. You might have to be an ICA member. I doubt that. I don't even know. I should know. Let me click the link. See where it takes me. Yeah, it takes me to. You got to pay Zach directly. He wants stable coin, no refunds. $600. I'm just kidding. Looks like it's going to be complimentary. But anyway, just click the link. It's going to be an interesting lecture. There's going to be introductions by Brian Beckham. I just said at WIPO. Zach, who's the general counsel for ICA, is going to give an introduction. And then some remarks by the one and only Gerald Levine. So certainly worth it. You're going to hear from a lot of scholars in the UDRP realm and world. And it's pretty cool. So check that out. It's July 21st. So it's on a Monday, just so you know. The other thing I wanted to mention real fast is I've been listening to this podcast, Off the Hook, because it's for hackers and basically it's really just for programmers, developers, people building stuff. And I'm listening to it because there's a gentleman who works for ENS, that protocol. His name's Alexander Urbelis, Alex. He's their chief counsel, their general counsel, and he's also a builder himself. But matter of fact, he's someone that I know they're going to be applying, and I'm going to speak with Alex about it, about who is getting to assist ENS, because they plan on applying for extension this next round. But I want to ask you, Jeff, before we move on, are you familiar with Alex? I know you guys I saw connections on, I don't know, maybe it was on LinkedIn, but Alex is general counsel at ENS. Are you familiar with Alex?
Yes, very much so.
Yeah, he's out of New York.
Alex was with, before ENS, he was with, I'm getting this out of order, but he was with the NFL. He was with a law firm before that, so I know he's done a lot of things. But yeah, Alex and I have talked a lot.
Great. I'm glad you know him. I mean, I figured you did, and that way, when I bring up, because he's being very helpful. He's working, he and his team, working with Chad and I, doing some things at PayNow, and so I mean, I was like, knowing that he also is on this podcast, Off the Hook. I like listening to some of the things that he talks about, covers, and I just find it really interesting. But I like that it's easy to catch up with people when they're doing a podcast. They can hear. I mean, the cool thing about the podcast, and David, I think you'd really like it, because they talk about developing and building sites, but they also talk about recent news. They're real progressive guys and fucking smart, and they are not afraid to touch on all topics. But I mean, I'm just really liking it. I was just doing it to catch up with Alex and see what he's been doing. Last week, he does these shows on Wednesday. It's out of a radio station in New York, which is cool as ice. I can't wait to go on this thing. He was in Prague too, and was called in from there. But no, I really like the guy. He's fucking smart and fun to work with, and just interesting all around. All right, so if you want to link to that podcast, you can check that out on our outline too, dnlshow.com. And I will make sure always we have an updated show link, so people can go and just go to dnlshow.com if you want to link to the replay, and you can just click right next to the show. It says show link. All right, we're going to get to our cases. The very first case is the domain TM7. That's letter number TM7.com. And this case, well, let me go here. It says Vorwerk International, VORWERK. Swiss company was the complainant. There was a Chinese registrant, Zhu Lizhu, that was represented by John Berryhill. So John represented the domain owner here. Fantastic. I'm going to give it away. Not only was it complaint denied, it was an RDNH. Okay, so I've given away the end of the book, which I love to do for myself, and I like to drive by movie theaters when it's a surprise ending and yell at the line, "The sister did it." Okay, so this was a case where the complainant makes household appliances for over 140 years. They're, like I said, out of Switzerland. They have these products. John had a really funny post. These products, they're like Thermomex is one of their product names. Anyway, so these products help you, measure the temperature of, I don't know, cooking products and so on. So it's like not next to a blender or next to a crock pot or whatever. I don't really know, but it's thermometers for household appliances. Well, they have a product that's named TM21, that's named TM20, TM5, TM6. Well, when this domain was registered, and it was registered back 2001, I don't know if that's actually when the respondent acquired it, but it was registered clear back in 2001. But no matter, it was registered before the complainant had started using the mark TM7. So interesting in this case, David, you mentioned earlier, like anticipating a mark. When you see a company, just like the iPhone 1, 2, 3, people are registering the domain iPhone 9, iPhone 12, now there's 16 or 17 of them, right? So there are ways to anticipate a trademark. This one unique in that it's only 3 characters. TM can obviously stand for a lot of things. Instead of Thermomex, it could stand for trademark, of course. But so this registrant registered it before they started using the mark, but the complainant made the case that, we got all these other marks that were registered before, that were registered way back. We've been doing this for 140 years. This person should have known anything with TM plus a number is our is our uh, is our company's mark. And since the domain resolved to a for sale page, complainant didn't like it, but John had a good response, and I'll throw it first to David, and then Jeff, you obviously jump in after that. But David, tell us a little bit about John's response and how he successfully represented this domain owner.
So the critical fact here is that when the domain was registered in 2001, Thermomix only had a model TM21. And there is no way that this respondent was able to figure out that they would go count down and like go jump down to TM5, TM6, TM7, 20 some years later, 25 years later. So it didn't make sense. Like there's just no way. He actually went into the psychic domain squatter type of scenario with quoting the Success Bank case that he successfully won for Zoot. And, I wonder what they would have said if I owned TM5.com, which would have been a great domain name for having a list of IDs for trademarks that match the top 5 countries, because there's something called TM5. And that's like Canada, United States, Korea, I think the EU is in it, and one other country. But anyway, so these this TM7 is not very distinctive. It's used by a lot of companies. There's a few trademarks out there to other companies. And yeah, so he goes through, it says he actually goes through the bad faith analysis, saying that he did not know, could not have known. And yes, the name is forwarded to the for sale page on pronames.com. And it said make offer on there. It was a list of other names. So he was just forwarding his domain to his seller site. And that's what people do. But is there any bad faith there? No, there's just no way you can prove that when the domain was registered, there was bad faith. Maybe, Jeff, you can fill in the blanks that I skipped over.
Yeah, I mean, it was a very tenuous claim. There was no way that, as you said, there was no way that when the domain was registered, that they would have known, that the registrant would have known, first of all, would have known who this company was, but second of all, that this company was going to, at some point in the future, not only use TM21 or whatever they had at the time, but then was going to use TM7 or anything else. And even if they had used TM7, the reality is that this opinion does recognize that, that I think they skipped the legitimate interest, which kind of annoyed me. But they certainly recognize that, that it's not bad faith to register dictionary or short terms that can have many different meanings. And so, yeah, I mean, I think you pretty much covered it. You can't really. There's no evidence here at all. And I think the other interesting thing about this one was it was just poorly drafted. It contained arguments that had no relation to the actual decision. Like it started analyzing Oki data, which is a case that we've talked about a bunch on the show, generally used with resellers and or authorized or unauthorized resellers or people that, yeah, it's either resellers, repair shops, things like that. But Oki data has nothing to do with this case. This respondent is not claiming to be a reseller or anything like that, and so there was kind of, I guess, Barry Hill, who has his lovely style and way, of writing these things basically said that, well, either the complainant here was just incredibly sloppy in copying arguments from other briefs or other cases, or it was drafted by AI. But it was not a complaint that showed anything, and it was totally reaching for some kind of claim. And it's surprising. This They're represented by a fairly well-known IP firm in Argentina, and so they ultimately found reverse domain name hijacking. Although it was touch and go there for a second, so I don't know. Yeah, it was a three-member panel, um, and Steve doesn't usually have an issue in finding reverse domain name hijacking if it's warranted. But Matthew and Flip, who are the other two, it was hard when you're reading it. They were like, well, normally you don't do RDNH just for losing, and you could have had a good complaint, but ultimately came around and said that um, they said, although a poorly prepared complaint is usually of itself insufficient grounds to justify a finding of RDNH in this case, it is in this case, at the very least, consistent with the complainant being prepared with little concern as to whether the complainant had a credible claim. So in this case, they did find RDNH, and I think it was the right result.
Yeah,
Yeah,
Jeffrey.
absolutely. And I found it funny when because I recognized the name. I met the person in charge of their legal department back, I don't know, 20 some years ago at an ABA meeting or an INTA meeting. And I was just shocked at the sloppiness of it. And then John linked to their website. He says, "Oh, they should have more than two lawyers there." And he was linking to their paralegals, but it's still like, who wrote this? It's definitely not top tier. And why would a Swiss company hire an Argentinian company to do this? Maybe because it was cheap. I don't know.
I'd like to have been. So it was a three-member panel, like you said, Matthew Harris, Flip Wilson. No, it's Flip something else, and Steve Levy, who of course we speak with, friend of this show, and comes on here. So this three-member panel, and like both of you mentioned, it was a sloppy complaint, and John pointed it out to appeal to these three panelists, and John said specifically, in the case, he writes this in there in his own way, right, to appeal to these panelists, whether bizarrely fictional allegations are inadvertently made through inept use of copy paste or AI, UDRP complainants do not have the right to inflict this sort of time wasting exercise of weeding out irrelevant marks and nonsense allegations on UDRP panelists working well below their hourly rate to provide a community service. So John basically was saying what Jeff and David summarized, and that is they were referring to cases that had no connection to this case, and just basically making a bullshit argument. And he said, this is wasting the panelists' time and needs to be addressed. And you guys don't even get paid very well to do this. And of course, the no panelist is going to say, yeah, we do get paid. Yeah, he's right. We're sitting here listening, and now we got to listen to his stuff too, to John's bull. But John was right, and you do it. You write all this to appeal to the panelists, really, to not just get their attention, but to be convincing. And he did. So in this case, he got everything. He got the complaint denied plus the RDNH. When that's all you can ask for if you're a domain owner, you feel like it sends a message to one. You hope it sends a message to every complainant out there to know, geez, if I'm going after this domain owner, they are not opposed to hiring this attorney, and they are successful in most of their cases. Basically, leave me alone. This is how I respond to complaints. Of course, a new complainant sometimes doesn't search that, okay, this respondent has been in other cases and has been successful, and not only that, has shown that the complainant abused the system. But so successful for John, congratulations. Another one, TM7, and wasn't, I'm sure it might have been in the response. I didn't see in the summary, but many times you'll say, look, this domain investor has registered many 3-character domain names, and then list them, and why 3-character domain names, short keystroke domain names, are valuable. I mean, or desired, maybe not by you as a domain investor. I sure like them. I got 50 of them. Is around the world, some people, some different companies really find these things attractive, and it's a reason why a domain investor would pick up a 3-character. Obviously, reasons other than targeting this company. So fantastic. The domain owner gets to keep dtm7.com. And we're seeing a lot of these 3 characters start selling more and more. I'll tell you, just when you're checking name bio out there, all my domain investor friends, check it out. I mean, learn a little bit about them. And if you can find some on the aftermarket, maybe less than 1,000, definitely, but less than 500 even. It may be something you want to, invest in, especially if you can get them less than $300. I think you'll be able to, they've held their value in that range, less than 300 for 20 years. So if you have one, you got a low cost basis, at least you'll be able to get your money back out of it. I don't know. I want to say not investment advice. I could give a shit. All right. The next domain name on our review agenda is prodryer.com. prodryer.com. And the single member panelist here was Alan Limberry. And I look forward to speaking with Alan. I agree with his decision here, although I don't like the domain owner's response. So I'm giving this one away too. It's a transfer. So this guy owns prodryer.com. Could easily be a generic or descriptive type name, but because of the respondent's actions in this case, that's what cost him the name. And I'll just mention a little bit about it. The complainant was Category 5 Technology. That was it versus Daryl Kirksey. He runs a company called Allied Hand Dryer. Okay, so anyway, the complainant provides these hand dryers and restroom equipment, under the Pro Dryers with an S, under that particular trademark. So Pro Dryers is their trademark. They've been doing it since 2008. You've all been into, a restroom, that has these dryers. You touch the button, right? So the complainant has a trademark for Pro Dryers. They've had it, like I said, since 2008. This domain name was registered in early 2020. The interesting thing about it, and I'm going to leave this for David to discuss, is it was originally included in the supplemental registry at the USPTO. And then it was moved, I believe, to the principal registry in 2025. So I'm not going to say more about that. I'll let David talk about it. But I wanted to just say, so this complainant had been using Pro Dryers to sell these, excuse my language, hand dryers. Okay, so it's pretty descriptive. Pro Dryers, he's selling dryers, with it. So you would think others could use also the term, you're selling a dryer, you can use the term dryer. No one can really, no one can keep you from using it. No one can really trademark it and successfully defend that mark. So another interesting fact, and then I'll be quiet, is the complainant purchased product from this respondent over the years. Early on, before they got big, the complainant would buy product from this respondent and resell it. The complainant got big enough to where then they were buying direct, just like this respondent. They're both in the same business. They make these hand dryers for restrooms. Well, the complainant eventually, it seems to me like they grew past the size of the respondent. Maybe not. We don't have the financials, because the respondent at Allied Hand Dryer did go to the complainant and say in 2020 and said, hey, I'd like to buy your business. So the respondent, doesn't mess around either. He wanted to buy the complainant's business. The complainant said no, but that's when he registered prodryer.com. Somehow he picked it up, and I'll do some research when David's discussing this, and Jeff, but he picked it up and then he pointed it to his website, and people were confused. People would go there and think they were going to Pro Dryers .com, with the S, and he wouldn't be very clear about, no, he wasn't that company. And that's really what led to Alan's decision. So Dave, I'm going to throw to you. Talk about the supplemental registry, how it moved to the principal registry, and any other facts you want to include.
All right, so the supplemental registry is for merely descriptive marks that are not deemed to be or not ruled to be generic. If you get on the bad side of an examiner, they will put you on deeming your mark to be generic and give you a solid refusal. So anyways, they accepted the supplemental registration back in 2011 after some back and forth. And then the respondent registered this pro dryer, which is a generic, merely descriptive term. It's professional dryers that they both sell. Neither of them manufacture them; they're made in China. So anyway, the complainant goes ahead and tries to reapply in 2023 to register their mark pro dryers, plural, on the principal register in 2023. So there is a 2024 office action saying, hey, you know what? We're going to maintain our November 2023 refusal. It's still merely descriptive. You haven't proven it's any better. And you've given us more evidence, but we don't accept it. So you have to fix the identification of your services. Thank you for doing that. But the new issue is Section 2F, acquired distinctiveness refusal. So as of 2024, this mark was still considered to be merely descriptive. And the problem I have with this decision is that the complainant failed to provide any evidence of distinctiveness as of 2020 when the domain was registered. So the complainant could not prove bad faith. They disclosed that they had a mark on the supplemental register, but Alan Limbury didn't understand the difference and just said, well, it's been 11 years and they should have known because they know each other, and yeah, they're competing on for the same business and they're trash talking each other. Yeah, but if you look at SpyFu, handdryer.com ranks a lot higher than prodryers.com. So, and you don't have any proof of acquired distinctiveness as of 2024, much less 2020. So what is your argument? It took them till the beginning of this year before they were finally able to convince an examiner to approve the trademark. So I think that Alan did a great disservice by failing to apply the proper principles of UDRP law. When somebody has a supplemental register, you better prove that it has distinctiveness. And Jeff, tell us how much proof that requires. Do you need surveys? What do you need to actually prove distinctiveness without a principal registration?
I mean, yeah, you need to show that the the, the relevant public, your relevant consumers, identify um, not just the product, but the product is associated with you as the um, applicant for to be on the principal register. So, I mean, yeah, you need surveys, you need testimony. I think the complainant said in here that, or it says in here, complainant provided evidence that the service mark Pro Dryers is well known by the contractors and business owners that have hand dryers installed as fixtures in the building, and that in the commercial restroom accessory industry, Pro Dryers had an excellent reputation for selling all commercial bathroom accessories, not just hand dryers. So, I mean, the UDRP is interesting because, well, it certainly doesn't recognize um, the supplemental register as being prima facie evidence of trademark rights. You can show it, and I don't know what they put in the complaint, but whatever it was, I think I think that Alan thought it was enough. Plus, I think the big thing here is that the respondent had a redirect um, to the website, to his competing website. So prodryer.com resolved to a website of the respondent allied hand dryer. So when you know something is the name of your competitor, and you then take that site, the .com, and forward it to your own site, you're kind of almost admitting, or you're basically saying that you took advantage of whatever limited rights the complainant had. The respondent, by doing the redirect and knowing who this entity is, essentially registered and used the name in bad faith. Um, I don't have
Jeff,
so
would your
much of an issue
analysis
with this.
change? Would your analysis change if you knew that ProDryer.com was owned by another competitor prior to 2020, and that ProDryer has been searched online according to Google long before the complainant existed? But that tend to make it indicate that it's a generic term, and that's why the examiner refused the mark?
Yeah, I know, because the facts in this case, I think it was pretty evident that the respondent was targeting this company, whether or not they had, the most perfected trademark rights or not. The respondent was targeting um, the complainant.
Yeah, there was the ProDryer term is most associated with, recently with the New York ProDryer 3200, but that's only recent. That's a breakout. But before, it was not searched. It's not. I think he registered in 2020 only because he was planning on acquiring his newly growing competitor, because big companies like to buy up the smaller companies. That's what they do to eliminate competition
Yeah,
to
it
grow
does. It
scale.
does say that there was some discussions back in that time frame about a potential acquisition um, of that specific unit, but that didn't pan out.
Well, I wanted to comment that this domain owner had a nice, solid defense that he didn't present. He basically almost just admitted, yes, I was targeting. I mean, I don't know all the full response, but that's think why Alan was like, this is pretty obvious. The guy bought it. He bought ProDryer.com because this competitor of his had a trademark for ProDryers.com, and he pretty much almost admitted it. I guess he did, because if he would have said, I have ProDryer.com redirected to handdryer.com because although of course I'm familiar with them, they used to buy from me, the term pro dryer is used in this case, this case, and I knew it was a solid generic descriptive domain name. I, of course, like you say, you've known about them. You're not going to deny that you knew about the complainant owning that mark, but then you go heavy with all these other uses of ProDryer and why that is generic. He just basically folded, in my opinion. The respondent just came in and said, I knew about them. I redirected. People were coming to me thinking it was them. And he further, confused people by not clarifying, no, I'm not them. So that really played into Alan's decision too, that this guy bought it because they had the whatever, like Jeff said, David, even if it's a weak mark, that they were still doing business as Pro Dryers. This guy bought ProDryer.com because of them and was really trying to siphon business off of them. It didn't have to be that way. He could have had a defense. He basically gave the complainant everything they wanted, sort of admitting this. Then he didn't refute the complaint good at all. So almost Alan's not hands were tied, but
Well, the response was only one sentence. The domain is no longer forwarding to our site. That's it. It was just one sentence.
okay, then
But
that
is
was
that
it.
implicit, what you just said? Maybe. But the thing is, it doesn't matter about the complaint's bad faith. The lack of evidence of secondary meaning in 2020 undermines the panel's assumption of a protectable mark. And that is the problem, because there's a statutory provision that actually says it's an admission against interest that mark is not registrable, not protectable. And that's why you cannot win a lawsuit with a secondary supplemental registration without secondary meaning. And even then, you won't get it. You have to get your principal registration, or you have to have a trial, which is a huge deal. So this is not a kind of case that should be, anything in the supplemental register should not be litigated through a UDRP, because you need evidence, you need cross-examination. This is something that I firmly believe should be thrown out. Never, ever should a supplemental registration ever qualify as a sufficient mark for purposes of a UDRP at the time of registration.
Yeah,
It doesn't matter, you just got it this year.
you've convinced me now. I mean, because if it was prodryers.com, if you actually had that, it's too bad. I have your exact, what you're doing business as, but it's very descriptive. It's exact describing the product. So, now you got me convinced that, yeah, in 2020 it was in the supplemental registry. It was there because it's considered descriptive. So even if you had that one sentence, which is not incriminating, but the panelist takes it as incriminating, meaning I no longer forward it. It's almost like you're admitting you shouldn't have been forwarding it. So you've convinced me, David. I think, yeah, this shouldn't have been a transfer. Begrudgingly should have been a complaint denied, even if Alan was not, thinking this person did have the complainant in mind, but you can't help it. It's a generic descriptive domain name. That's the bottom line, and the USPTO agreed, especially at the time when the guy acquired ProDryer. But okay, so I think Dave, you convinced me to change views on that one. We're going to go to this next case, go through it fast, talk with Domain X about his comment. Thanks for sticking around, and then we're going to get out of here. School's out for the summer. Betplays.com is our last case for today. BETPLAYS.com. So you can imagine BetPlays. This anybody using betplays.com, probably somebody in a casino, a sports book, or so on. So this is why considered a descriptive name. BETPLAYS.com. Registered in 2006. The complainant in this case, Corredor Empresarial. Anyway, it's a casino, an online casino gambling service out of Colombia. They're the complainant. There was an individual, Theano Andrew, I believe anyway, Creative Alliance. He was out of Israel. So they're both in the same business of providing gambling services online. The complainant, really big, been using the brand BetPlay without the S. BetPlay is their mark that they, basically the name they do business under since 2017. So they are on the domain, excuse me, betplay.com.co. Plus, they have several other domains that forward to that, but they're pretty big. They sponsor the national Colombian football team, the soccer team. So they do a lot of marketing. Everybody in Colombia is well aware of this company. The respondent has been using their site for the last 3 years, since 2022, and they're in Curacao. I think that's how you pronounce it. So they've been also doing a gambling site, and but they're somewhere else in the world. And they're basically, the respondent said, listen, I don't do business in, they did respond, I don't do business in Colombia. Colombia prevents, you to do business if you're outside of Colombia. So you can't have a gambling site in that services Colombia if you're outside of Colombia. So they were like, that's, of course we didn't even know about this company, and they also submitted some other evidence that showed several other companies that used BetPlay, and I think they had a fairly good defense here. It was a 3-member panel. I'll send it per se. How about you, Jeff? What do you say about this case, and share the decision?
Yeah, I mean, I think so. You kind of mentioned it in the facts that uh, this company sure was able to show that it was famous in Colombia, but not, and potentially some Latin American countries, but it was not. There was no evidence there that showed that its fame was known outside of um, Colombia or Latin America, and certainly not where the respondent is in Israel. The respondent also is a licensed provider of gambling services, where the respondent lives or works, or where this business is. And so, although they not kind of, they skip the whole rights of legitimate interest, which I'm not a big fan when panels do that. But they skipped the legitimate interest, rights of legitimate interest, and ultimately found that um, the respondent doesn't have any customers in Colombia. The respondent's licensed in sorry, the respondent's licensed to provide online gaming services in Anjuan, where the respondent's located. And it says, in the absence of evidence, to the extent which those authorities took into account the extent to which respondent's trademark conflicted with other person's trademarks, this consideration would not necessarily be decisive in and of itself. Um, but it says that the complainant has not established the respondent is targeting complainant's trademark, and so has not proved that the respondent registered and is using the disputed domain name in bad faith. Um, they the respondent requested RDNH, but the panel said, um, although the complaint was not successful, the panel does not consider that a finding of RDNH is appropriate um, in the circumstances of this case. So no RDNH, but the respondent, one, showed that it had was not targeting. I think they established that they have rights or legitimate interests, but the panel skipped that element. And yeah, so it's the right result. I think, uh, I think, like I said, rights and legitimate interests should have been filled in, and they should have made an affirmative finding. But at the end of the day, same result, that the respondent gets to keep the name.
I found it interesting that the complainant filed their annexes in Spanish, but the complainant, the proceedings in English, and the applicant, sorry, respondent is in Africa, someplace in Africa on an island, apparently. So that was interesting. Have you ever seen a case dismissed as a preliminary matter for failure to disclose material facts? Because that's one of the things they try to do in this case.
No, I mean, like I think it's when a respondent, or sorry, when a complainant provides the actual registrations in the language in which they're obtained, I don't believe that you have to do translations of those. If you're going to submit other evidence, that's not like formal legal documents, but other attachments, that needs to be translated. But to me, as long as it was just for the most part the proof of registration, I don't think those need to be translated. And then they said here at the end of the day, it didn't. Obviously, they're found for the respondent, so it didn't impact the decision.
I found it interesting how Colombia actually actively blocks gambling sites that are not licensed in Colombia. So that's an interesting thing. So you could operate with the exact same mark outside of Colombia. If they don't have a mark in your country, you're dead in the water, according to this decision. Is that what you read?
Well, if you're not licensed to provide those services, then they are gonna block your DNS. Um, a lot of countries do that for a lot of different reasons.
This case could have turned out like case number two if there was not a solid response or not a response from this domain owner, because very similar, they're sort of generic names. Bet plays, bet play is used by a lot of different companies, but David, anyway, good point that if you're using something in the gaming space that's identical, of course you feel like you have a right to it. Why? Because you can't do business over there anyway. You're not qualified to do business in Colombia. So how could you, disrupt their business? Your servers are blocked. But okay, so that was a complaint denied, no RDNH. And Jeff, you mentioned it. The panelists, this was a three-member panel, said just because the complainant loses the case doesn't mean it's necessarily RDNH. Well, of course not. Otherwise, so many of the cases are not, RDNH. We know that's, true, but still, they didn't really explain um, why, they just felt like, hey, they did have a right to go after them. They just wanted this domain name. They liked it with the S. When you're on betplay.com, .co. I'm sure you'd like to have this one with an S. All right, I appreciate everybody being here. Domain X was here last week. Had a comment about a domain that he registered, and Jeff, we were telling him as long as you don't, you're not targeting this particular company because it was sort of a generic name. But I don't know if that's the same comment or question he has. Domain X, welcome. Thanks for being patient. What's your comment or question?
Yeah, so I had researched further into it. So the trademark is basically registered in Germany, and they have also applied for WIPO, World Intellectual Property Organization. Like I'm new in this field, so like maybe I may be like spelling something incorrectly. Yeah, they have filed, but they have not got from the WIPO. They have just in Germany. So if they go in case in UDRP, in this case, will they take the domain away?
Okay, say what trademark that they've applied for and then give your domain name again, please.
Yeah. So the domain is freestylechess.co and .ae.
So let me say this for Jeff and David again. David, I know, is aware of it. This gentleman has freestylechess.co
I'll just
and
type it in chat.
and freestyle.
Uh,
Yeah, I got it. Freestylechess.ae. But anyway, he's got a couple domain names. Freestyle Chess. Freestyle Chess really is a style of chess. Okay, it can be. Now there is a company I believe it was on freestyle-chess.com. But anyway, he is like, geez, they probably interested in the domain name. We said, of course, you don't want to contact them and say, I have this. You're the only person I think would want it. Like you don't want to set out that you're targeting because it's it is can be considered a generic, a descriptive domain name. So we were basically giving advice. He wanted to know right now, Jeff, if they file a UDRP, you know, what's the likelihood of him losing the name? What type of defenses would he have? And also, what should he do to, you know, not target? Any advice you have for him owning a name like this, knowing there's trademarks out there and that they also filed for this WIPO? Explain what that is. What do you file with WIPO?
yeah, yeah.
I can help.
They have
I can help with
filed.
WIPOs.
First let David. David's going to explain what it is to
Sorry,
everybody. Domain
sorry.
X,
Yeah,
and
yeah.
then Jeff
Please
will
go
jump in.
on. Yeah.
So WIPO has something called the Madrid Protocol. So if you have a registration or an application pending in a Madrid country, then you can, like the United States is a Madrid country, then you can apply to WIPO for a Madrid protocol and designate a bunch of countries. You pay per group of countries. There's a fee that ranges, if you have 5 countries or 10 countries or more, they just charge you. It's a graduated scale, but you don't actually get registrations in those countries. So even though it's considered or called a international registration, it's not actually a real registration that's enforceable. You actually have to apply within a year in those other countries or within the time period that you're allowed for your WIPO application. And that will give you an ability to enforce it in that country if you actually get a registration. But usually those secondary applications are refused for a variety of reasons. One big one is that the identification of goods and services is not consistent in all Madrid countries, and that is a primary reason for refusal. Other reasons can be the mark is confusingly similar to other marks within that country, or the mark like chess, freestyle chess would be considered merely descriptive or clearly descriptive in some countries, like the United States and Canada. So it depends. Now, if you had a .eu, I'd be concerned because they have a registration in Germany. But If you have something else, then I think it's okay. But I would develop the site, put something on there, explain what freestyle chess is, because that's new to a lot of people. I know there's something on Wikipedia, but maybe have a video of explaining like this is how it differs from regular chess. I think that would be useful. So you actually promote the sport.
Thanks, David. Thanks for your valuable inputs.
Jeff, any comments on this domain name?
Well,
That
okay,
question.
so I just did a little searching. So, I mean, freestyle chess refers, there may be some trademark. So, there may be rights there. I would certainly steer clear of it, and I would, uh, if you're using it, um, you have to make sure that you're, using it in conjunction with its descriptive category. See, I don't know enough about this sport, but or this type of chess, but according to the brand itself, that freestyle chess is the brand, but the type of chess is called Chess 960.
Okay, to chime in, hold on, Domain X. I wanted to say, so Jeff brings up a good point. Maybe freestyle chess is not as generic or descriptive as we think, because it certainly sounds that way. What I would do is find many users, many different, even hopefully there's other tournaments, but anyone else that uses the term freestyle chess outside of that person, that company that has the mark, because then you want to build up. They use it, they use it. I planned on using it in a fair way, like these other folks are using it, you know. So need to look and see who else is using that term, in that generic sense, descriptive sense, and hopefully there's several others because, when Jeff brings it up, it makes it sound like, maybe it is, very limited. They brought it, they brought freestyle chess basically to the table. They sort of invented the name and they started having tournaments with that name. Then you would be more boxed in with regards to what you're going to be able to do with it. But it sounds descriptive. Anyway, any other comments you have, Domain X?
Yeah, thanks, Todd and Jeff, David, for the inputs. One more question I had in relation to that. I was just checking the UDRP cost. So, having one panelist and having three panelists, what is the difference? Like from I'm not used to all these, that is why I'm asking. Yeah.
Well, I mean, part of it is a cost determination, right? So if you're if you're a respondent and you only have one panelist, the complainant's paying all the cost. If you have three panelists, then you're splitting the costs, and it's like a couple thousand each. But on the positive side, if you really have a strong case, there's a better, or if the case, I should say, if you believe you have an incredibly strong case that there's no way anyone could, find in favor of the complainant, then maybe you're okay going with one. But if it's a well-known trademark or a trademark owner or a good attorney on the other side, but you still want to be assessed fairly, I would, if you have the means, choose three.
So Domain X, it's $1,500 for them to file. That's going to be a single member panel. You respond and leave it as a single member panel. You're going to not no fee for you. If you select a three-member panel, it's going to go up to $4,000, and for the cost of the filing, you're going to pay two of it. They're going to pay an additional $500. So now you both pay $2,000. The only way you can have a three-member panel and not pay anything is if the complainant recommends that with their complaint, or requests that with their complaint, and then they pay the full amount. So if you as a respondent request a 3-member panel, you're going to be paying $2,000. That's a WIPO filing. Keep in mind each service provider has little different charges, but WIPO is, like I said, $1,500 to file. It's $4,000 for a 3-member panel, and if you request that as a respondent, you're going to pay $2,000, and then the complainant's going to pay $2,000. So thanks for clarifying that, Jeff, and that's it. Anything else?
Thank you. Yeah. Thank you. Thank you, Todd. Thank you, Jeff.
Hey,
Thank you,
thanks for
everyone.
being here,
Thank
and
you
thanks for
for
being patient. Thanks for, those questions are helpful to everybody because, when you have a generic type name or you think it's generic, one, whether it seems descriptive like yours or not, you certainly don't just reach out to a one trademark owner because that appears to be targeting. So when you do reach out to someone who you believe would be attracted, interested in purchasing your name, always let them know you're sending out to several different potential buyers. You think there's a lot of different folks that would be interested in this name. They're just one of them, and you're making them aware of it. That's always, better to do. You still need to be careful depending on the name and who you're reaching out to, because some companies are more litigious than others, have filed a lot of UDRP complaints. So if that's the case and you're reaching out to one of them and you have a domain with their mark in it, you can probably expect, a UDRP. And like I said, if they have a history of filing. All right, everybody, thanks for being here. Check Josh and I out on Thursday. We're going to do this room. It's called DNX Show. It's solely about domain investing. It's Thursday morning, my time, 10 a.m. Pacific, 1 p.m. Eastern. That's on Thursday. And of course, we're going to be here next Tuesday, noon Pacific, 3 p.m. Eastern, for another episode of the Domain Name Law Show. Thanks again. Enjoy the rest of your day.
Thanks. Appreciate all everyone's input. Thank you.